also got joining us today former Digital Solicitor General Biswajit Bhattacharya with us on a whole host of issues. Mr. Bhattacharya, appreciate your patience. Thanks very much for joining us. Your first comments on what we've seen transpire today in the bitter boardroom battle with Cyrus Mistry tendering in his resignation from 6 operating companies. This is now a matter that's headed the legal route.
Well, the legal route, I personally feel, is quite undesirable. You know, a settlement, a bad settlement is better than a good litigation. Now, once the boardroom battle spills over to the courtroom, I think all concerned lose. Litigation in these matters do not enhance the interest either of the group or its shareholders or the members or the employees or the outstanding reputation of both Mr. Tata as well as Mr. Mistry. They should have sorted out the matter. They can still do it. And I'm just repeating, they should have settled the matter inside the boardroom. It may have been a bad settlement for both, but good litigation, like my friend Mohan Parasaran just now mentioned that they have a very strong case. Mohan, of course, is a good friend. He was the Solicitor General and I was additional at that time. He's an outstanding counsel. But the question is, however strong your legal case may be, you don't know. Ultimately, the court of law's decisions bristle with uncertainties. And it's very unfortunate that such an outstanding group, and there has been this kind of a acrimonious, exchanges and allegations.
And if one goes by what we're seeing today, it's only going to get far worse if this is headed to the courtroom, as Mr. Mistry points out. But Mr. Bhattacharya, I'm going to come back to you, sir, on a whole host of other issues that we need to discuss. But here are legal experts, experts who've been involved with this bitter boardroom battle for the past 8 weeks. Also, trustee of the Sir Dorabji Tata Trust, Mr. V.R. Mehta, speaking exclusively to CNBC-TV18 on what they make of this big development. Listen in.
My reaction would be that Mr. Mistry has done what he should have done on day one, that he should have retired gracefully from all the chairmanships and directorships of the operating companies, which was merely a corollary to his being the executive chairman of the Tata Sons. And in accordance with his own guidelines for governance in the Tata Group, which he formulated in 2015, any person, Tata person, who holds an executive position, once he leaves
Mr. Mehta, I'm sorry to interrupt you. And again, go ahead.
Once he leaves that executive position, he should resign from all the other positions that are there that he holds in the company. He had not followed his own guidelines, and it's good that he has followed this now, and it should be good for everyone.
But how would you read this, Mr. V.R. Mehta? He says in that statement, I'm shifting this battle to a larger platform. How would you react to that particular statement?
I have no clue as to what he means by a larger platform, and whether he's going to move some other agency or what, there's no indication. I wouldn't like to speculate on that.
I think it's a very wise decision because the real battle is the misuse of public funds. After all, the Tata is a charitable trust. It belongs to the people. And now the Supreme Court has, in the BCCI case, laid down the principle that there's no such thing as a private thing which uses public funds and caters to public interests. So after all, Tatas have been taking money from the public, and how it is being utilized is a part of the general interest of the public, and so it's a matter in the public domain.
I think it's good news that he has resigned because this comedy show has to stop. Cyrus had no support. People felt bad at the way that he was removed as chairman. Maybe Tata Sons should have called a shareholders meeting and removed him because shareholder democracy is final. Now that he has resigned because he has no support, I think this should come to an end. A lot of damage has been caused to the shareholders of Tata companies which are listed because of this battle, which is of no avail. It is essentially ego battle between two individuals, two sets of people. I heard about the trust not getting dividend, but I don't know. If you look at the track record, there is nothing to say that there's been no ups and downs all over these years. I think that's just an excuse. Essentially, an ego clash between individuals, but now it has come to an end. But shareholders have the ultimate right to appoint directors. He has no support. I think we should put it behind us and get along, and hopefully the Tata Groups will focus on creating greater shareholder value for everybody and do better.
I would like to say that we should salute him for this gesture. I think it is bringing an end to a extremely difficult and sordid portion of the history of governance in India. And the larger forum, which I believe, and this is my understanding of larger forum, is the hearts and minds of people, hearts and minds of regulators, and hearts and minds of everybody who wants to take India to greater glory. That is what I interpret to be the larger forum in which this battle will now move. And I think it is extremely good step.
I think what has happened is that Cyrus Mistry has realized that there's no point in going ahead with the EGMs because it's a foregone conclusion. The voting will go against him in view of the voting power of the Tatas and some of the financial institutions. Therefore, I think he has taken one step backward to take two steps forward. And those two steps forward would now be to take the battle to the larger arena of the regulatory authorities and possibly the courts, because he knows that unless the law is amended, unless Section 169 is amended, he has no chance of being reinstated. Therefore, possibly he will move towards making sure that the law is amended, that the independent directors cannot be removed by a group majority of the principal shareholder. And this is where the battle will now be, to ask the government, to ask the regulatory authorities to make sure that independent directors' positions are protected.
Our support for Mr. Mistry was grounded on the fact that he has always been calling for better governance structure, better terms of reference between the operating companies, Tata Sons and the Tata Trust, and the fact that there is non-transparency between Tata Trust, and there was no compelling reason for Tata Sons to remove Cyrus Mistry, and they had not articulated any, not even a single line reason. And so I think, of course, this resignation by Mr. Cyrus Mistry has come as a total surprise, though not unexpected, because, of course, the results were sort of stacked against him. But that doesn't matter, actually. See, investors need to think of what better governance structures would be put in place in the Tata Group. This instance, unfortunate though it is, over the last 2 months, has clearly shown that Tata Group is this one for bad governance. I mean, one cannot just attribute good governance just because of reverence or just because of the name. One has to look at the details of what good governance means. What are the disclosures? What are the terms of reference between a holding company and the operating companies? Are there conflicts of interest between the trustees and the directors? Yes, even today there is a huge conflict of interest between trustees and directors. So these are questions that investors need to ask.
Well, a diverse set of reactions there coming into the big story of the day. Biswajit Bhattacharya, the former attorney, additional solicitor general, still with us. Mr. Bhattacharya, you were talking about how any legal battle is fraught with uncertainty. But if you were in the Tata camp today, and if I would ask you to anticipate what their legal strategy would be, what would you say they should or could do now to protect themselves legally?
I personally feel that what Mr. Mistry has done is right, and I think both of them now should shake hands, and both of them should basically realize that the corporate governance basically demands that at the time the alleged, contraventions which are now being alleged, everybody in charge of responsible are jointly and severally responsible. I mean, I can't be at the helm of affairs of a company. I come out and say that when I was in charge 2 years back, this is what has happened. Then if you make that allegation, perhaps a part of it comes back on you also. So therefore, they should further both the groups, both the warring factions should join hands, further their common interest in a concerted manner in the larger public interest. After all, corporate governance is extremely important. You have to look after the interest of the smallest of small shareholders, members, financial institutions, creditors, employees right from the peon right to the, chairman. Everybody is expectant that the company should basically contribute to the national growth. It should create additional resources. This is no way. I think, I don't know the full facts, so therefore, whatever I have read it in the press, nor am I a counsel representing either of the parties. So, but I think what is happening is extremely unfortunate. Somebody should have intervened. By now, somebody very big ought to have intervened so that this kind of a mudslinging doesn't go on beyond a point.